quick assessment of the new legislations that are on the anvil and some which have been notified by the government, as well as the measures taken by the government in light of the COVID pandemic. So Jane's presentation is going to be broken into 3 sets, and they're interspersed with, we'll have a break of a few minutes between each session so that people can get a quick bio break, or if they just want to jot a few points down. Jane's presentation will be followed by an open session, which will roughly be between 30 to 45 minutes, which will where you can ask your questions or have some reflections on what you heard. During the course of the of Jane's session, if anybody feels there's a dying urge to share their thoughts or they want to raise their questions, please feel free to put in your questions in the chat box. And since we're running behind time, I'm going to hand it over to Jane. Jane, are you good to go?
Yeah, I'm good to go.
Perfect.
Hi. Can you hear me and see me?
Yes.
Yeah, it's okay. Okay. First of all, hi everybody, and million apologies. We had a trial run at 11 o'clock. It was fine. I had a video conference an hour ago. It was fine, and our internet connection here just collapsed. I'm very sorry for all of that. I was at the inception going to give a warning that I'm not so used to technology, so just bear with me a bit. But this is really taking the biscuit. Another thing I just like to say, I know I have a weird accent and I have a huge amount of material to cover and short time. And I will tend to get faster and faster. So if I it's difficult to the symbol, especially when it's written by Sanjay Singhvi on the history of labor law, and some research on the recent codes done by our interns Rahil and Gansham. Now, I'll be breaking the session into 3 or 4 different parts. I was asked to stress on the 4 new labor codes that have been introduced by the government. They've somewhat, we were all most anxious about that. They've somewhat been knocked into the shade by the drastic level of the amendments now introduced and being introduced in the name of COVID by a large number of state governments. I will deal with those in the last session. So first of all, to understand the changes that are being proposed by the codes and by the COVID legislation, it's necessary to understand our present law. And to understand our present law, we need to understand the history of how it evolved. So what I propose to do in the first session, I'll discuss the various acts as they evolve, the history to their evolution. And as I come to each act, deal with it briefly, so that then in the second session, we'll go on to the changes being proposed by the 4 new codes. I'm putting a rider to that. The 4 new codes, there are 4 codes which cover 29 old legislation. They are huge. One of them has 163 sections. One has around 104. I can't possibly cover all that, and it'll be really boring, and we will lose the wood for the trees. So what I propose to do, even in the history of the law and the present law, try to concentrate on what I feel are the very crucial acts, especially in terms of labor jurisprudence and the collective rights of unions and trade, of workers and trade unions, because I think that is particularly crucial. And I'll concentrate even on the changes on those areas, so that we get a broad view of what the law is and what the main changes are, so as not to lose the wood for the trees. So I will start with the first session, which is the development of Indian labor law. Many will be aware that probably the first labor legislation in India was the Factories Act of 1881. Now we know the Factories Act today, which provides for 8-hour working day, which is being changed to 12 hours by many of the state amendments, which I will come to. The 1881 the conditions of workers were so bad that the 1881 Act, all it did was prohibit the employment of children below the age of 7, and then prescribed that for children below, between the ages of 7 and 12, it was a 10-hour working day with a 1-hour break. That was it. This also came, this had in fact, at the beginning, I should say, all of the labor laws which we have today have come through struggles of workers, whether direct, indirect, or on account of political situations globally or nationally. Now, this Factories Act, the welfare that came for Indian workers came indirectly because it came as a consequence of the Lancashire mill owners in England wanting to render the Indian mills less competitive. And therefore they forced through this legislation. However, the English working class in England had struggled and got their rights under the Factories Act for reduced working hours, which was the very reason that it had to be enacted in England. So ultimately that also came through the struggle from a working class struggle. The 1920s in India saw a huge slew of legislation, and some of the most important. That is for 2 or 3 reasons. One is that the 1920s saw a large amount of strikes, especially amongst the textile workers, textile being one of the main industries at that time. And there were a huge amount of strikes for increased wages, better working conditions, and working hours. Now this led to some of the legislation. Further, you see things like the ILO being formed around this time, but even the ILO was formed in a political context. A lot of revolutionary activity taking place, particularly the Russian Revolution of 1917. And we'll see that a lot of, even in the 1940s, where a lot of the welfare legislation that has come in for workers has also been of governments conscious that they should try to make revolutionary politics or communism less attractive, and therefore providing some welfare measures and rights for workers. And it's important to see the preamble to the ILO Convention, which says that the conditions of labor invoke such injustice as to produce unrest so great that peace and harmony of the world is imperiled. So the impetus was to save the peace and harmony of the world. And we'll see as we go through the legislation, and particularly the Industrial Disputes Act and the precursors to the Industrial Disputes Act, ultimately or primarily, they have been introduced to curb strikes and curb any stoppage of production or man hours. So we have to bear that in mind while seeing this legislation and the new amendments. So with that background, in the 1920s, there was a large amount of legislation introduced. 1923 is the Workmen's Compensation Act, which provides for accidents at the work, accidents, injuries and diseases at the workplace. 1926, one of the most important pieces of legislation till date, Trade Unions Act. Now, most important because without a trade union, you won't have a trade union and an organized working class, you won't have labor legislation. And without the trade union, what labor legislation comes, you will not be able to implement. Now, again, the impetus for the enactment of the Trade Unions Act was a strike. And it was I've talked about the wave of strikes, but in particular in 1926, there was a strike of the Buckingham and Carnatic mill workers, sorry, in 1921, a strike of these workers in Madras for increased wages. The management took the striking workers and their leaders to court through a civil suit in a civil court. Not only did the civil court give a stay order against the strike and injuncting the strike, but it fined the leaders 7 lakh rupees in 1921. Now, 7 lakh rupees today is huge. Imagine what that was in 1921. Now the workers collected that money. They collected with support from other workers. They collected you could form a trade union with just 7 members. However, an amendment a few years ago has laid down that although you only need 7 members, only 1/3 can be members from outside the industry or establishment, and that can go up to 1/2. Sorry, that can go up to the office bearers. Only 1/3 of the office bearers can be from outside the industry or establishment, and in unorganized sector that can go up to 1/2. Now, that is, as many trade unions have found this a bad move, because though in terms of workers' democracy, one would always be for encouraging independent or trade unions with maximum workers' participation. In many situations where you have illiterate workers and where the bargaining power is particularly low, the outside office bearers are crucial, and therefore this has been seen as a pretty anti-trade union act. Also, amendment that came in a few years ago, which is maintained in the new act, is that to form a union, although you only need 7 members, you must have 10% of the membership in that particular industry or the establishment. The other important point under the act is now though the trade union is referred to as a body corporate that can sue and be sued, so it can sue on behalf of its employees, no trade union leader or member can be sued for doing any act in furtherance of an industrial dispute for constraint of trade or business, or for inducing somebody to breach an employment, which is precisely designed to deal with the situation in the Karnataka mill workers case, where they got an injunction on the ground that the strike was in constraint of trade. Importantly, the Trade Unions Act in India, as it stands today, does not have any provision for recognition. In Maharashtra, you all will know that we have the MRTU Act and MRTU MPLP Act. That's a Maharashtra Recognition of Trade Unions and Unfair Labor Practices Act. Under that act in Maharashtra, if you're governed by the state government, then if you have 30%, at least 30% majority membership and at least 30%, then recognition will be granted, and that union will be the recognized union. Any settlement signed by that union will then bind workers even if they are not its members. I believe there's also similar provisions in Madhya Pradesh and in a few other state acts, but in central legislation across the board, there's no concept of a recognized union. There is under the new codes, but as yet, at the moment, there isn't. There is those familiar with the public sector will know there's something called the Code of Discipline, which was set up in the 1950s as a tripartite agreement between the government, the employers, and the central trade unions. And for public sector, there's an agreement that there will be a code of discipline governing recognition or a negotiating committee, but that is not, it's nowhere enshrined in law, and nor is it justiciable. Now we come to the other very crucial act of the 1920s, which ultimately evolved into what we have today as the Industrial Disputes Act, which is the mother of all acts. And that is in 1929, the Trade Disputes Act. Now, this was the first legislation brought in India for settlement of industrial disputes and for providing some machinery for settlement of industrial disputes. Again, it arose due to a need to control the wave of strikes. And in 1928, there was a huge Bombay textile strike, and this act came as an answer to that, and essentially provided that prohibition of strikes and lockouts in public utility services without giving notice, okay? But only in public utility services, which is the law as it stands today. It's not the law as it will be if the codes get amended, which I'll come to later. It also provided for conciliation boards and courts of inquiry, but they were to be, there was no standing court, no permanent court. Those were to be set up on a case-wise basis. And there was no, any order or award given was not binding or compulsory. So this Trade Disputes Act had major limitations in dealing with industrial disputes, but it did serve the purpose of controlling and restraining the strikes which were going on in the textile mills. Another very, very major and crucial act of this time, which remains one of the most fundamentally important labor legislations till date, Payment of Wages Act. The most basic right of all workers is payment of wages. So this act is absolutely crucial. It provides, for example, that wages are to be paid, when wages are to be paid, they're to be paid on the 1st of the month or the 7th of the month if there's more than 1,000 workers. It gives it prohibits the deduction of any fines or deductions from wages apart from those listed therein, which include, for example, for disciplinary action or welfare contributions, etc., which was very crucial because at that time, otherwise deductions were being made left, right, and center, as they still are today for contract workers and unorganized sector. It also provided, importantly for the workers, a machinery for the recovery of your wages. If you don't get wages, where do you go? If you remember, Trade Disputes Act is just there was no compulsory machinery there. So this act set up an actual machinery. And to date, there's a authority under the Payment of Wages Act, and that is given, some states give that power to the Labour Commissioner, which is frankly much more accessible and easy for workers because they can go themselves. And in other states like Maharashtra, it's at the moment given to the courts, which means that workers have to, even for recovery of monthly wages, they have to go to the court. Also, you can only recover the wages due at that time. You can't ask for the continuance of wages thereafter. And the problem with the act is it has a eligibility, it has a threshold. So they laid from time to time, they revise the maximum wage. And if you earn above that, then you don't come under the act at all. Now, recently it's been increased to 24,000. Earlier, it was much less, to the extent that it would knock out a large amount of workers. As on today, it's 24,000. Okay. Am I talking too fast or it's okay? Okay.
You're absolutely fine.
Okay, good. Now we come to the next lot. And next lot of legislation, which is the post-independence legislation in India, and the legislation which came with independence and with the end of the Second World War and the whole post-colonial era, which that brought in, along with the multinational companies and the Bretton Woods institutions such as World Bank and IMF. And there was we see such a slew of legislation and leading legislation at this time, because with this new, with the MNCs and much more internationalization of production, they needed to have some sort of standard laws in industrialized nations. So many countries saw legislation coming in at this time, as did India. One of the most important acts, which to date again is one of the most important acts, though many people are not so familiar with it, is the Industrial Employment Standing Orders Act of 1946. Now this applies only to establishments where there are 100 workers. In Maharashtra, by a state amendment, it's 50, could well be less in some other states. This is a crucial act because it First of all, it not only lays down the entire rules and regulations to be followed in a company vis-a-vis its workers, but most crucially, it gives the classification of employees, i.e. under what head can an employer employ a worker. So it's classified as permanent worker, worker on probation, a buddy worker, a temporary worker, a casual worker, or an apprentice. In 2016, which I will elaborate on this when we come to the codes, because according to me, this is the probably the amendment in labor law, which has is the most devastating and takes away the root of much of Indian labor industrial jurisprudence that we know today. And that is that they've now allowed fixed term contracts. Okay. But that was by an amendment in 2018 to the existing act, which is also continued in the new code to come. Prior to that amendment, you could not, the only notion of a fixed term contract was in the Industrial Disputes Act, and it was referred to as an exception to paying retrenchment compensation. But now it's since 2018 been introduced as an actual term of contract, meaning you can recruit a new employee on a fixed term. Okay. Up until now, however, the courts have largely because the litigation has been under the Industrial Disputes Act, retrenchment compensation, many judgments have interpreted this to mean that only a fixed term contract can be given where the work is not of a permanent nature. It would normally be used where, for example, you're appointing a worker on a project, or you're appointing a worker where the work is of a fixed term, but it cannot be abused to deny permanency benefits for work of a permanent nature. That is, there are many judgments on that, but as we'll discuss it later, that may be a thing of the past. Apart from this, the Industrial Employment Standing Orders Act lays down the entire rules and or rather a large blueprint for the rules and regulations in the establishment. For example, mostly crucially, what can be misconducts, and an employer, it's been held many times, the employer can only take disciplinary action against a worker for one of the misconducts enumerated there. If it's not enumerated, then it's not recognized as a misconduct in law, and you cannot take action against somebody for any misconduct. It lays down the disciplinary procedure, for example, that an inquiry must be held, that you have a right to defense representative, who that defense representative can be, that you must get subsistence allowance, what is the level of subsistence allowance. It goes into great details on shift timings, notices be put up for shift timings, leave, annual leave, etc., and what grounds a worker can be terminated. So for workers for whom this act covers, the act is, and it lays down model standing order. It's as per this act, each company has to get its own rules and regulations certified, but it gives the model standing orders outside of which you can't go unless it's more beneficial. And in Maharashtra, as and until certified standing orders are framed, then the model standing orders will automatically apply. So this is a very crucial act for the organized sector. We spoke earlier about the Disputes Act. In that, as I said, that was found to be, apart from prohibiting strikes in public utility, it was found to have major shortcomings because it didn't provide any permanent courts or conciliation machinery, and nor were any orders binding. During the war, the government got over that with the Defense of India rules during the Second World War. And these rules continued the prohibition on strikes in public utility. Sorry. Yeah, I'm sorry, I'm working from a phone. Sorry about that. It also provided for that provision for the government to make a compulsory reference. Can you hear me? Hello?
Yep, we can hear you.
Yeah, okay, sorry. It hung from the phone. It also made provision for compulsory references to be made by the central government to industrial courts. So that, and for the order given by the industrial courts to be binding for the first time, okay? This is what led to the Mother Act, the Industrial Disputes Act in 1947. Okay, now there's a lot of confusion on the Industrial Disputes Act when we've been having discussions on the on all the latest amendments brought in during COVID and the notification for payment of wages, which has been passed by the government. People keep on talking about the rights of workers to wages, etc., under the Industrial Disputes Act. The Industrial Disputes Act does not confer rights in that sense. Those rights come from the other acts which I've talked about, like the Payment of Wages Act, the Industrial Employment Standing Orders Act. What the Industrial Disputes Act prior to chapters VA and VB coming in, what it did was provide for this is the first fully fledged act which we have for providing for a machinery to deal with industrial disputes. And I'm sure, as any of the practicing labor lawyers or trade unionists here would say, my experience is basically it ties workers and unions up in a long drawn out procedure, which frankly was its intention. If we go back to the intention, if you remember, the 1929 Act was basically to curtail strikes and any action which would impinge on production. So what the Act does is it's provided for a full sorry, I thought I had it there. In the preamble, this is made clear from the preamble of the Industrial Disputes Act, which says there's a need for machinery for industrial disputes, binding settlements and award. The defense of injured rules proved useful as an interim measure for the above and proved useful in checking industrial unrest. So the Industrial Disputes Act has main thrust is to ensure that there's no industrial unrest by providing quite an elaborate machinery. And the whole point is that unless it's for recovery of wages under section 33(1) and 33(c)(1) and C2, workers cannot go directly to court. Unlike under the MRTU Act in Maharashtra, under the Industrial not go directly to court, you cannot get go and get a direct stay, which really hampers the workers and strengthens the arm of the employer, because anybody can be terminated, any action can be done, and then you go to court to get it corrected, and we all know how long that takes.
Jane.
Just one more thing I was stressing: workmen and employers, or workmen and employer, but workmen and employers. It's not workman and employers. And there's a whole series of emphasizing that an individual worker cannot raise a dispute. Now that led to a lot of discrimination when it came to unions not taking up cases of workers, for example, basically for termination. And therefore there was a amendment made, I think in 1964, section 2A, which now which says that termination, discharge, dismissal will be deemed to be an industrial dispute, even if it's in respect of one worker. But otherwise, there's a very strong reason why the Act only deals with industrial disputes, because although there's no concept of a recognized union here, basically it's a question of collective bargaining and setting up a machinery for collective bargaining, and so that all issues will be done through that process. Okay, that will also has huge relevance when we come to what I think is the most dangerous and major change in the new codes. If you could just bear that in mind for that. Now, the Act sets up this machinery. So basically you raise a demand, you go to conciliation, which is before the Labour Commissioner. After, if there's a settlement, then they settle. And this is, if there's a settlement, then it will be binding on the parties who sign the settlement. If it's signed if it's signed in conciliation before the conciliation officer, it will bind everybody, whether you're a member or not. If there's no settlement, then the conciliation officer sends a failure report to the government, and then the government decides whether to make a reference, and then it finally goes to the court. So it's a very long-winded process. That was the main thrust of the Industrial Disputes Act as it originally stood. And then, and the other part was strikes and lockout. And it maintained the earlier provision, which was continued in the Defence of India rules, that you only need to give a strike notice in public utility services. This is very important. Other industries do not need to give a notice of strike. Only those in public utility. You have to give 14 days notice and go on strike within 6 notice. The other thing, which will have again major relevance when we talk about the amendments which have come, under the Act, it's laid down that you cannot go on strike or impose a lockout after the commencement of and conciliation proceedings. Conciliation is treated as proceedings, and there's a further section that though a conciliation officer has a discretion whether to take a matter into conciliation or not, if it's a strike or lockout, he has no discretion, number one, and number two, the proceedings commence the minute the strike notice lands on his desk. So if the employer gets a strike notice and sends it to the conciliation officer, the minute it lands on his desk, that is treated as the time when the conciliation starts. And if your strike has not already started, then you're prohibited from going on strike, which essentially means it's legally impossible, almost impossible, to go on legal strike in public utility services. And this is something to be borne in mind when we come to the changes. That was the Industrial Dispute Act as it stood. And then the chapters VA and VB were added, which are probably the most famous: for retrenchment, compensation, layoff, and closure. Chapter VA applies where there's more than 50 workers and essentially lays down that retrenchment compensation is payable to any worker for 15 days for every day worked. Layoff, 50% layoff wages to be paid, and closure compensation. Again, you get company closes down, then you have to pay the same amount, pay the retrenchment compensation as if retrenched. And if the company has got more than 100 workers, you come under VB. And for all of these things, you'll need to take permission of the state government. So that's basically the Industrial Disputes Act as it stands today. I'll go through quickly now the other major acts which are there. Minimum Wages Act 1948. Important thing to note is that as it stands today, there's no one minimum wage. There's no and nor is there a floor level. That means that each state fixes a different wage for each industry. The logic behind that being that different industries have different profit levels. So you can't compare pharmaceutical with plastics or glass, for example, or engineering. And therefore, as on today, you have a long list of scheduled industries with different minimum wages being prescribed for each scheduled industry. ESI Act of 1948, setting up the ESI corporation, medical facilities for workers, contribution from the worker, contribution from the employer. Provident Fund Act doing the same. Important to note that though the Provident Fund Act initially says the contribution will be 10%, but or as notified, it's 12% today. But in the yesterday, the package that was announced by the Finance Minister, there were a lot of clarifications that though the government will be paying the Provident Fund of Workers, both employer and employee, it's down to 10%. Mines and Plantations Act 1952 came in 1952 for mines and plantation workers. Crucial Act in 1970, Contract Labor Act. Okay, this came again in a different era from what we're in now. It was referred to in the first Labour Commission as a pernicious system. It's called the Contract Labor Regulation and Abolition Act. Those of us who have practiced in it know very well it's regulated more than abolished, to put it very mildly. However, it provides that there must be registration of the contractor and the principal employer. Please remember that, because that's very important when we come to some of the new major changes to come in. It lays down welfare facilities which the contractor is to give, all sorts of registers, musters to be maintained by both the principal employer and the contractor. There is Section 10, which provides for abolition, where the appropriate government can abolish the employment henceforth of contract labor on a number of conditions. Essentially, if the work is of a permanent and perennial nature, it's incidental to the main work, that means connected with the main work. It's sufficient to employ a significant number of full-time workmen and ordinarily done by permanent workers in other establishments. The teeth have gone out of that section since the decision of the Supreme Court in the early 2000s, 2002 or something, in the sale judgment, which held that if you somewhat flabbergastedly, if you abolish the contract labor system under Section 10, you also abolish the employment of the worker, and the worker goes out with the contractor. And all the worker can do is then go back under the Industrial Disputes Act, go through that long winding procedure, raise a demand for permanency, and end up in the court and spend another 20 years fighting for permanency in the court. So since that judgment, frankly, no unions other than suicidal unions have gone under that section, because to abolish the system is to abolish your own employment, which means apart from the sham bogus cases, there's not a legal attack on the contract labor system. 1965 Payment of Bonus Act, very important. That also came, the history of that was in the Second World War, the mill workers demanded bonus where the production was so high and the profits were so high, and that the concept evolved that you will get a bonus in the years when profit is made. There were more strikes on this, especially amongst the mill workers. It was incorporated in many awards of the tribunals. There were commissions, and essentially a commission in 1961, and that led to the act in 1965. Now, almost at the end of the acts, basically the acts after that, Migrant Labour Act, the Building and Construction Workers Act, and the Organized Sector Social Security Act. Now, given today the plight, to put it mildly, of the unorganized sector, these should actually be the most important acts. Frankly, they provide very little, very little. The Migrant Labour Act of 1979, compulsory registration of the contractor and the principal employer. Please bear that in mind for when we talk about the changes. It does at least some very rudimentary rights of payment of wages, the day on which the wages are to be paid. Passbook is to be issued by the contractor, and displacement allowance and journey allowance is to be given by the contractor. And very importantly, that if any loans are outstanding, particular to the contractor or the muqaddam who has brought them from the gaon, if any, in the classic bonded labor situation, if any loans are outstanding by the end of the employment, then those loans cannot be claimed by the contractor or the muqaddam. But it's a very rudimentary act which really sums up the rights and plights of migrant workers today. The Building and Construction Workers Act came in 1996 along with the Levy Act. However, though it provides for the setting up of boards by the state governments, it's not like the Security Guards Act, whereby which makes sense that the wages are paid through the board to ensure that the workers get their money, which is a very crucial provision. There's nothing like that under the Building and Construction Workers Act. Basically, it provides for the state governments to set up boards and to set up various schemes, and the Levy Act levies a 1% of profits from the builders, 1% of construction costs minus the land, which is a big issue. So the land gets minus from that. But we've seen that most of this, very many of the states have not even brought any of the schemes into effect. And the first package that was announced by the finance minister at the beginning of the lockdown, and so much hoo-ha was made about this being given for unorganized sector and the construction workers, it was actually being that money with 2,000 rupees per worker, it was taken by the money lying dormant in the funds that have been collected from these cess of the employers over the years, but no schemes brought out for the workers. And that money is being used. So that is actually already the money of the workers to start with. And a very important aspect of the Construction Workers Act is that registration, again, unlike the security guards board, where the workers go and directly register with the board, registration is to be done only on the verification of the contractor. Now, it's pretty obvious what that means. And I guess the other day that maybe only 10% of construction workers are registered with boards. That's possibly putting it very high, because the whole point is that which contractor is going to verify that a worker worked in? They don't want to. They don't want to admit that they're working in the way. I mean, for very obvious reasons. And finally, we have the Unorganized Sector Social Security Act of 2008. Again, it sounds very grand, but all it is defined unorganized sector, including home-based workers and self-employed, and provided for both the central government and the state government to have, through their boards, to set up various schemes. And it also incorporated a number of yojanas and schemes which were already there. And as anybody working in the sector knows, these schemes are more in their absence than their presence. So friends, this is I know that was huge. I've tried to give a whole gamut of labor law for organized and unorganized sectors as it exists today. I think, Kranti, do we have a break? Let everybody.
I think a break is necessary from both ends. Just before we take like a 3-minute break, we're going to play some songs. Like we discussed in the earlier part of the day, the talk today is spread over 3 parts. One was an overview of the legislation that subsists for today. And what Jane has done is she's picked on particular aspects of it, which gives you a flavor of what the law intended to do, and particularly those aspects which is sought to be altered in the second part of the talk, which focuses on the new legislation on the anvil. And then we'll come to the third part, which is about what is the government doing currently to deal with the epidemic. Jane, you're saying something?
It will be shorter. The next 2 sections are short, so please don't worry. And I'm anxious that we have time for discussion.
Yeah, so the songs were curated by Jane, and the song that we're playing right now is "There's Power in a Union" with Billy Bragg. That's a 3-minute break. That's a 3-minute song. So if anybody would like to take a bio break along the time during that period, please feel free. We'll resume in 3 minutes. Joel, we can't hear it. You might have to unmute yourself. Jane, are you on?
I'm here.
I just wanted to share this. This was also the lead song in a movie in 2014 called Pride, which was a docudrama of which arrested events in 1984 and 85, where queer folks and the mine workers in the United Kingdom came together to support each other. First, the queer folks supported the mine workers who were protesting against Margaret Thatcher's economic policies, and subsequently Labour supported the queer folks in bringing rights for queer folks to the mainstream agenda, and it led in a subsequent watershed moment when a lot of the rights of queer folks were recognized. On that note, Jane, back to you.
Okay, so now we're on the question of the changes brought in by the new codes. Now, before going to that, I just want to stress 2 or 3 things. One thing is, at the heart of Indian industrial and labor jurisprudence is the notion of collective bargaining. Okay, it's absent, as I said earlier, under the Industrial Disputes Act, it doesn't recognize a dispute apart from dismissal and termination, which is individual. It's all concerned with collective disputes because it's concerned with collective rights, okay? And even in a judgment, for example, of the Bombay High Court Justice Loader in the Hindustan Lever matter, where Hindustan Lever had entered at the end of the lockout in 1989-90, some I think 18 months lockout Hindustan Lever had. The management got forced the workers to sign an agreement giving up their wages for the lockout, okay? And they took individual undertakings from each worker. That was challenged by the union, and the Bombay High Court struck down those agreements and held them to be void on the ground that an individual agreement is an anathema to the Industrial Disputes Act and Indian labor law, and they were held to be void. And the courts would only recognize collective agreements, okay? The other thing is that Indian labor law, and this is why it's so very exciting, it's a fundamental exception to the basic tenets and principles of classic contract civil law. Okay, classic contract law is that the court will only enforce a contract or interpret a contract. It's in a tiny number of cases where a court will ever hold a contract void or voidable. For example, whether it's vitiated by fraud, misrepresentation, or the parties are incapacitated to act through, for example, insanity or being minor. And the chances of getting something of proving fraud and misrepresentation are, I mean, that bar is very high. So normally the courts will not modify or vary a contract. It's only a question of interpreting what was the agreement between the parties. Labor law is the complete opposite. Labor law, for example, you may not even have a written contract, okay? But labor law and the courts will read into your contract of employment all laws, all labor law legislation. So if you have a written contract and, for example, it says that you're on probation, you can be on probation for 9 months, but the model standing orders under the Industrial Employment Standing Orders Act say that it's only 3 months, then your contract will be held to be invalid to that extent, and the provisions of the Standing Orders Act will prevail. And even if so your contract of employment, whether written or unwritten, all provisions of law will be read into it. Another thing is, in civil law and tort law, you cannot have specific performance for a contract of employment, a contract of service. It cannot. Also, if you are in civil law, if you are terminated, so for example, employees who are non-workmen, if they're terminated, all they can do is go to file a suit and ask for damages, but they cannot ask for reinstatement because you don't get, you cannot have specific performance of the contract. Labor law, as far back as 47, the federal court, prior to the Supreme Court, the federal court in the Western Automobiles case held that the courts can create a contract and they can direct reinstatement. And in, for example, wage adjudication, where workers raise a demand for wage, they want for wage increase, changes in service conditions, including those which are not laid down in an act. If that goes for adjudication before an industrial tribunal under the Industrial Disputes Act, then the industrial adjudicator can change the contract, modify the contract. He'll say instead of 5,000 rupees, you'll be paid 10,000 rupees. Instead of this formula for DA, you'll get this formula for DA. Instead of this washing allowance, you'll get that washing allowance. He'll add things, he'll minus things. So the tribunals actually modify drastically modify and change the contracts between the parties. And at the base of all of this that I've just said, and at the base of the very heart of labor law and industrial law, is a recognition of the intrinsically unequal bargaining power between the two parties. Now, any contract will, if you have reliance in some Chintu company, obviously there's going to be unequal bargaining power, but that's the, that's the system. And the law will not take that into account. In industrial law, it takes it into account because by the very nature of the classes, you are going to have the workers are intrinsically at an unequal bargaining power. And that was recognized very specifically by the Supreme Court, by Justice Madan in the leading case of Brodinov. So this, I've emphasized this a lot. Why? Because now I've come on to the the changes to be brought. In a while, I'll go through the specific acts, but I want to highlight before you, having given this big background of the law as it stands today and the ethos behind our law, I want to now emphasize the 3 or 4 things which are proposed to be brought in these 4 codes, okay, which strikes at the heart of this. And the biggest one is the concept of the fixed term contract, which is now it was introduced in 2018 in the Industrial Employment Standing Orders Act, but I mean, not everybody, to be honest, has been so aware of it. It's now come in under the Industrial Relations Code, which is the first of the, or one of the new codes. It's come in under that specifically in the first schedule as one of the types of employment, along with permanent employment, temporary, casual. Now this, frankly, this means that now, up until now, when you get employed in a company, your service conditions will be the same as those for the other workers there, which have been fixed by a settlement with the union or with the or an award laid out by the tribunal. As per this now, you will have individual contracts entered into. Now, there's a rider that the same wages and service conditions should be given to fixed term contract workers as the permanent workers, okay, and that they will be entitled to the same termination benefits proportionately. But frankly, number one, once you start having a contract negotiated individually with the individual worker, that will probably be more on paper than actually enforced. And the major thing, if you have a fixed, can you see?
Yes.
Yeah.
Yep.
Fixed term contract means
Changes, you've frozen up for the last 10 seconds.
the management, they're out, sharply out at the end
Jane,
of the...
we lost you for the last 15 seconds.
Sorry, can you hear me now? Hello?
Yeah, we can hear you now. We can hear you now, but we lost you
Yeah.
for the last 15 seconds.
All right, go ahead. Fixed term contract, even if an employer guarantees that he will pay the same wages as permanent workers, but a fixed term contract means you will be employed for 1 year or 2 years or 3 years or whatever is specified. Once you put that limit, no worker will agitate against management. No worker will unionize. No worker will take any stand against the management, because she or he will realize that if they take any stand, then the minute their time comes to an end, even though the work they're doing is of a permanent nature, and even though the work continues, their contract will be terminated because the management doesn't want them around. And I think that can be seen of all sectors. If you see something like journalists, who one would expect to be one of the more stronger, one of the stronger workforces and more able to represent themselves. In the early 90s, there were no fixed term contract in journalism. People were on a regular permanent contract and governed by the service conditions and the wage boards. The managements, wages of journalists went bananas in the mid 90s. They went bananas because they put everybody on an individual contract, told them to come off their existing contract, put them on a fixed term contract, doubled or trebled their wage. There's no unionization. And in the early 90s, the journalists had a very strong union, and now the unions are really weak because journalists moved on to fixed term contracts, and those who are on the regular contract were entitled to wage board wages, which is fixed nationwide across the country by a wage board. Those on fixed term were not on that. So we've seen an even stronger workforce like journalists, their unionization and their strength too. And now their wages have been, once they got almost all of them onto a fixed term contract, now their wages have been cut, which everybody knows. So this fixed term contract, which is being brought in by the Industrial Relations Code, strikes at the heart of or labor rights, if you ask me. The other thing is strike. The same industrial relations code now, if you remember, for strike, you only have to give prior notice if you are in the, for public utility. Now it applies for all industries, not just public utility. So you have to give, not only do you have to give prior notice for strike, but if you give prior notice and that notice goes to the conciliation officer, it's taken into conciliation, then you cannot strike once the proceedings have started. So this means essentially it will be difficult to strike in any, to strike at all, because the proceedings will start and then you got, the strike will become illegal. The other big area is Contract Labour Act and definition of contractor. The under the existing, much as we know it's difficult now to oppose contract labor system, nowhere has in any act, including the Contract Labor Act, nowhere has employer been, has a contractor been included in the definition of employer. And now we find in all 4 codes, the contractor is included in the definition of employer. That along with the definition of contractor now under the Occupational Safety and Service Conditions Act, a contractor includes somebody who supplies workers as mere human, I think the word is mere human labor, is going to make it almost impossible to challenge the contract labor system, even as sham and bogus, which again, highly advantageous for the employers. Now I'll quickly go through the provisions. There are 4 codes, okay? The Industrial Relations Code takes over 3 acts, that is the Industrial Disputes Act, the Trade Unions Act, and the Industrial Employment Standing Orders Act. The Occupational Safety, Health and Working Conditions Code is a long title and it's a long act. This replaces 13 acts. It's humongous and it's incongruous because it covers acts from the Factories Act right through to the Working Journalists Act. So one, and it's jumbled all sorts of acts and rights together, which frankly don't belong together, and in the process made a total mess. The Code on Wages replaces 4 acts, that is the Payment of Wages Act, the Minimum Wages Act, the Payment of Bonus Act, and the Equal Remuneration Act. And the Social Security Act, this replaces 9 acts with 163 sections. Now I know where I said I wouldn't talk long, and I already have. So let me just skip through the some of the salient features, and then we can go on to discussion. Sorry, my battery's about to run out. Sorry. Under the Industrial Relations Act, there's a very important judgment passed yesterday by Justice Gugay of the Bombay High Court, saying that the government directive for payment of wages must be followed, and that was in a case of temple workers. Now, the definition of industry, or the definition of industry under the Industrial Relations Act now will expressly exclude charitable, social, philanthropic services and spiritual and religious, which up until now, as per the judgment of Justice Christian Iyer in Bangalore Water Supply, was included. So that's a very big thing. Recognition has now been introduced. If any union has 75% majority, which is frankly almost impossible, then it will be recognized. Otherwise, there will be a negotiating council, and a seat will be given for 1 seat per 10% membership, which frankly I feel is very unmanageable, and we'll end up with 1 seat for every 10%. It seems to me it'll become a jing bang, and not much will get actually settled. Under the Occupational Safety, Health and Working Conditions Code, the hours of work, nothing is laid down. Under many of these acts, it's just everything is put as to be prescribed. So it's stated that the hours of work will be as to be prescribed. Annual leave, some improvements. Annual leave has been slightly increased. Women can now, with their consent, be allowed to work between 6 a.m. and 7 p.m. But creches under the old Factories Act Earlier, they would be there if there were 30 women employed in the industry. Now it's 50, okay? Working journalists have been included under the definition of workman, and electronic media journalists included, but the whole wage board structure for journalists is gone. So frankly, whatever they had under the old law, everything has gone. There's one section on construction workers, one section which says that they can't be employed if they have impaired hearing or impaired sight. Code on wages. Minimum wage now, it's not industry wise, it'll be a flat minimum wage, which the central and will be fixed by the state governments, but the central government will fix the floor level, means a basic minimum wage, and above that the state governments can lay down their own. And under the, so I'm going fast because I know I've taken a lot of time. Under the Social Security Code, the huge one with 163 sections, PF is now reduced to 10% from 12%. Maternity benefit is positive. There's now 26 weeks maternity leave and also 12 weeks maternity leave for adoption, but that had already been brought in a 2018 amendment. There's an amendment to the for unorganized sector workers. They've introduced gig workers, which is a worker who performs work or earns from such activities outside of the traditional employer-employee relationship. Very vague, I don't frankly understand that. And platform worker, who's in employment in an organization which uses online platforms to access other organizations or individuals to solve specific problems, seems to be online workers. And the central government can just provided that the central government can notify various schemes for social security and for the unorganized sector, nothing specified. I think, Kranti, I think that was a huge second session. Hello?
I was, there's a lot of information download happening and wondering what questions would be like. But what we could do is we can now do a break. There's another song that's again created by Jane. A change is going to come, and Sam.
I would suggest, Kranti, should we go into questions after this session, because otherwise it'll get very long.
Yeah, and this will also give Jane a breather. So Joel, don't forget to unmute yourself.
I can't hear very well. You take off the. Very difficult to hear the question. How will I put them in this question?
Need a professional logo for your brand? I've used the new Wix logo.
Jane, we're back. Are you around?
Yeah, I'm here.
Jane, before we open up the floor for friends to maybe reflect on what they heard and maybe ask questions, do you want to just reflect about the last session, the last part of the talk, which was about the steps that the government has taken in the last few weeks around workers' rights and the pandemic?
Yeah. See, there are 2 or 3 categories of this. The first thing is under the Factories Act. Now, 10 states have taken out amendments to the Factories Act on the working hours, okay? Those are Gujarat, Himachal Pradesh, Rajasthan, Madhya Pradesh, Haryana, Maharashtra, Uttarakhand, Punjab, Goa, and UP, okay? All of them are providing for 12 hours working day, okay? Now, they've done it either under Section 65 of the Factories Act or Section 5 of the Factories Act. Under Section 65 of the Factories Act, you can grant exemption from working hours, okay? So you can go above the normal 48 hours a week, but you can't go beyond 60 in a week, okay? And only Punjab has limited it to 60. Everybody else has given for 72, okay? And Gujarat and UP have quite astonishingly said that there'll be no overtime payment. Okay, now that is under the Act, you cannot exempt from payment for overtime. India, so that's totally legal under the Act to start with. It's also against the ILO convention, which classifies, which holds that to not pay overtime at the given rate would amount to bonded labor or forced labor. So it would also amount to forced labor under the Constitution of India. Some of these states have passed it under Section 5 of the Factories Act. Section 5 of the Factories Act allows you to exempt from provisions on the grounds of public emergency, but public emergency is defined as whereby the security of India or any part or territory therein is threatened, whether by war or external aggression or internal disturbance. Now, everybody may be talking about COVID as a pandemic and like a war, but this definition makes it clear that it's something to do with war or a physical attack or rebellion, and COVID can't possibly be brought under the ambit of this. So therefore, it's clearly illegal. Number two is pretty horrifying at a time when you're emphasizing that people should stay well nourished and well rested and healthy to avoid contracting COVID and spreading COVID. That at that time you're pushing working hours up to 72. And the other aspect is on the 7th of May, we saw 3 industrial accidents. The horrific one in Vizag, which killed 12 workers. There's one also in the thermal power plant, the boiler explosion in Tamil Nadu, and Chhattisgarh, the gas leak in the paper mill. So, and these were, especially the Vizag one, which is being reported as the new Bhopal, was clearly due to industries setting up after the lockdown with a reduced workforce in hazardous conditions. So this is particularly alarming. The other type of amendments which are truly alarming is UP and Madhya Pradesh, but especially UP government has granted an exemption from all labor laws to all industries for 3 years period. Apart from there's some exceptions, which is, for example, I'll tell you, law in respect of women and children, Workmen's Compensation Act, Section 5 of the Payment of Wages Act, that is the date on which your wages are to be paid, bonded labor, and for the levy to be paid under the Building and Construction Workers Act. Now they provided, apart from that, for 3 years, all labor law will not apply in the state of UP. I mean, this is quite unfathomable and scary. It hasn't yet come into force because under section, I think, Article 254 of the Constitution, Labour being on the concurrent list, any state amendment of central legislation requires a presidential assent, and therefore what we understand is it's pending for presidential consent. But this is truly horrific. And all I can say is, as the saying goes, everybody loves a good war, or some people do. Okay, Kranti?
Yep. The floor is open. Does anybody have any questions or reflections? Some have messaged me privately to say that there was a lot of information and they're still processing it. No, that was the intention. While people are collecting their thoughts, I just wanted to share the idea of today's session really was to open a discussion that will help us roll into study circles in the future around various more specific issues around labor rights. And if any of the participants in today's Zoom session are keen to join or discuss any specific issue around labor rights in the future, please feel free to write it to us. And we hope to facilitate some study circles around both the existing legislation as well as the new provisions that are on the annual. Yeah. Jane, I have a few questions. So while people are, and this is collated from some of the discussion that's been happening. One of the this sounds like it's stepping out of what you covered, but one of the things that we've noticed over the last 6 to 8 weeks has been that one is the visceral face of the state's disregard for migrant workers, right? Which is where you have this exodus of a human population that doesn't feel a sense of belonging within urban spaces and are moving back to to where their homes are. On one end, and on the other end is that the one aspect that's not getting talked around so much is this invisible crisis around livelihood for a lot of workers who are not getting paid. It ranges from domestic workers to even multinational corporations who have announced wage cuts or have franchisees, and therefore they do not have a direct connect to the multinational corporation, and there's been no money to take home. In all of this, we're seeing two things happening. We're not seeing enough workers organizing around their rights. One, and wherever they're organizing, it's largely being portrayed as a law and order situation. So that's the first question. The second, you've emphasized a lot on what are the systemic challenges to doing that. And in light of the pandemic, organizing yourself as a collective is all the more challenging. The second question is that a lot of our unions have got into a humanitarian mode of trying to ensure that workers have access to some sort of nutritional security and are able to start making their way home. In light of these two developments, how do you see the working class or the toiling class organize itself, and what are you anticipating will happen both in the near future and the near immediate future, let's say in the next few days, in the next few months, as well as in the next year or two?
That's a huge issue. One thing that struck me, we had a webinar with Ms. Indira Jai Singh a couple of weeks ago, and she said something which I think is very pertinent, that just as 30 years ago, domestic violence was not a mainstream discussion, and now through the 30 years of the women's movement and legal and legislation coming out of that, domestic violence is now very much a mainstream topic and being put on the mainstream map. One thing is that in the atrocities we've seen of migrant workers, I mean, one can't say anything less than that. It is bringing attention to that sector which has been totally ignored, and it's bringing some mainstream attention to that. And I think that's something that we have to channelize, not just in terms of welfare, like all this, the 2008 Act in terms of welfare, but we have to somehow channelize that now into some more mainstream rights. So I see this in some ways as an opportunity, a very cruel opportunity, but an opportunity now to put some of these issues on the map. We have to, in terms of ways to organize, unions are mobilizing, unions are challenging these new amendments which are coming, but we've also seen the scope before the courts, even prior to COVID, the scope of challenging these sort of attack on rights, the scope before the courts was shrinking, and now in the middle of the in COVID, it's really difficult. The unions are doing that. They're also, I've heard, mobilized, thinking of some action to be taken at the moment. For example, how do you take industrial action? It's so difficult. It's so difficult because the workers aren't there. And if you take, for example, also I represented the Safai Kamgar. We didn't get the order from the High Court for them to be given the most anything more. They were already getting only one mask and one pair of gloves a month. We didn't get an order for that. Somebody said, why don't they strike? They're a contract and they filed for permanency in the industrial court. If they strike, that's the first thing the BMC will be waiting for. They'll be thrilled for it. So it is a huge challenge as to how workers will take this forward. One thing is, for example, I mean, it's different from a type of seminar thing, but I think we've all found with technology during the lockdown, we've all had meetings and planning sessions, whether legal or non-legal, with people throughout the country on things like this, on Zoom, and which we'd never done before, and we've had serious brainstorming. So that's, I think we're going to have to look into all sorts of new ways of protesting and coordinating.
Three more questions, Jane, thank you for that. Three more questions have come in. I will just read them out. One is from Fuzzle Boy, where what he's looking at. His question is, just one sec. how likely is it for the UP ordinance to get the president's assent? And the second is from Saranga, where her question is that the central government's notice about payment of wages to workers and non-recovery of their rent during lockdown doesn't seem to provide any mechanism of enforcement and redress. States have also not clarified any further on this. And the question is, where does the worker go for the redress of the above? Jane?
Hello.
Yeah, Jane, did you get this?
I'm here. Yeah. I got the first question. I think I got the second one. So I'll just deal with Rahil's question, I think, on the presidential assent, correct? On the UP.
Yeah.
Yeah. What can one say? The UP government is BJP, central government BJP. So those dynamics are there. It's up to all unions and organizations to ferociously oppose it and take it up at every level, because it is truly terrifying. So the chances are there. The opposition will have to be very fierce. The second question, I lost it halfway between. It was a question on the notification of the central government in respect of wages and rent, correct? What was the exact question?
Where do workers go for redress of the above, which is basically about the payment of wages and the non-recovery of rent?
Yeah, that is an interesting, it's interesting because the notification was passed not under any labor legislation. It's passed under the Disaster Management Act, and it's passed under the same clause and section of the Disaster Management Act that the lockout was announced under. And it was announced as a lockdown was announced under, I'm used to saying lockout. And it was announced essentially as a lockdown measure to ensure the success of lockdown, so that people won't go out. And that's why one of the main reasons why why it's been prescribed that wages cannot be deducted. That's been challenged by a large number of employers. It came up 2 weeks ago. The Supreme Court has kept it, didn't give an interim relief, but it's coming up tomorrow. So we're all appearing in that tomorrow. But where workers go for, because it's been passed under the Disaster Management Act, along with various other measures. It wasn't just wages and rent, it was various measures to make the lockdown successful. It's interestingly made the local district magistrate and DCP of police personally liable for implementation. So what we've been doing is, where workers have not been paid, writing a letter to the management and then immediately writing to the DCP and district management, okay? And under the Disaster Management Act, I think it's section either 72 or 71, the jurisdiction of all courts is ousted apart from the Supreme Court or High Court. So the short answer is, you can go to the DCP or magistrate, they're not going to do anything. After that, you can, if they're a group of workers, they can approach the High Court against the, even again in where it's a private employer, against the failure of the DCP or magistrate to take action.
Yeah. We do not have any more questions for the time being. Jay, do you have any more reflections on a few points that you might have wanted to cover, but we would cut short by time?
I think I pretty much exhausted. I think I probably given people so much information, they're a bit stunned. I feel I mean, we now have two lots of onslaught on workers. We have the 4 codes, which are 3 of them are lying before the Lok Sabha, and one has already been it's been notified, the code on wages, but it's not yet been brought into force. That will come whenever the government. I mean, it just has to name the day for that. And now we have the COVID situation. It's a it's the grimmest situation trade unions and workers have been in. And what can I say? It's we all have to do a lot of brainstorming as to how to deal with this.
Jane, some questions have come in from those who are now signed in on Zoom, but are on the YouTube channel. The question, one of the pertinent questions that are coming up is, what legal remedies, what legal remedies do migrant workers currently have to recover wages for the period of the lockdown? One. Yeah. And the second question was that for the near future, given the scenario that you have shared with us, your analysis of what the near future looks like, how do you see young lawyers and lawyers contributing their bit to the fight that's shaping up in the near future. So from your experience, so many years of working with workers and workers unions, what do you think is necessary for lawyers, particularly young lawyers, to do to join the fight?
Yeah, two very good questions. Migrant workers, the same law applies. It applies for all other workers. So that the same notification that was issued under the Disaster Management Act applies for the migrant workers. So they can either apply. I'm saying legally. I know the actual practicalities of all this, but in law they can go to the Labour Commissioner or to the DCP or to the District Magistrate. And if there's a group of them in who are employed by one employer or one contractor, let them do it collectively, and then we can these issues can be taken up by lawyers in the High Court, because that's the only way to do it fast. If everybody starts going through all the long-winded labour legislation, they won't get it, and migrant workers are desperate to get 1 or 2 months wages, and that's it. They can't stick around for a long fight. In terms of young lawyers, this is young lawyers getting involved in labour law now is crucial. Okay, it's you can see from the talk that labour law is complicated. I think if you can get the gist of maybe, I don't know if Karishma and everybody who's here would like to say something on this. If you can get the gist of labour law, then you can get the gist of most laws. But once you've got it, it's a fascinating subject, and we are up for the fight of our lives now. This is going to be one of the, even legally, it's going to be one of the dynamic areas of law, because now we have 4 codes which will replace 29 earlier acts. And we have this COVID legislation. So the courts are going to be awash with new interpretations, new approaches to the acts, new rights. And we are going to be flooded with workers who have also in this period not been paid wages, etc., etc. What we need is young lawyers to come in. Please come in, and it's going to be I mean, I hate to use the word exciting and dynamic in such tragic times for the workers, but this is going to be a very dynamic time for labour law, and we need young lawyers. So, I mean, it will also be an interesting areas for young lawyers to come into. So please come.
Karishma, do you or any of the other young lawyers, Saranga, you're here, but I think you have a mic issue, but would anybody want to join Jane in sharing what you think?
But hello.
Yeah, Karishma, you've been unmuted.
Yeah, I mean, I completely agree with Jane. I wouldn't want to call it exciting in this situation, but it kind of is. It's the only, I think when you enter the profession as a young lawyer, you're so, you really want to make a difference. And especially in litigation, you want to see your work bearing some fruit really quickly. And this is the biggest opportunity that you're getting, because it's actually going to interpret the law. You're going to help shape the law. And I think more than anything else, we are finding already in the last few weeks that we need help. We can't handle the kind of work we're getting right now, because there's just so much litigation in terms of labor law. So just work-wise, there's a lot, and there's a lot of good work that's coming in. So I don't see why someone should not enter labor law at this point of time.
Yeah, thanks, Karishma. If anybody else has any reflections, please feel free to raise your hands. I'll just quickly share an update. Shaalaa is hosting
questions or comments. Kranti, even comments.
Yeah, questions or comments. There's Gayatri. Gayatri, do you want to say something? I've unmuted you, Gayatri.
We can't hear her.
Yeah, I think.
Oh, we can't hear her.
Yeah, all right. While we wait for somebody else, some other friends to share their comments, I'd just like to quickly share an update. Shaalaa is hosting a call tomorrow with friends from the National Union of Sex Workers, where most of the speakers tomorrow are practicing sex workers from various regions of the country, and bring with them their experiences through the various different gender lenses that they have. Please feel free to join in. Like today's session, too will require a registration. Yeah, on that note, let me just check if we have any more questions. Jay, there's one last question that's come in from Anima, and her question is more of a reflection, but I think it also would call for your opinion. and it is, how do you see the definition of contractors could twist for the bricklane workers? What are the worst, which is one of the worst ways of exploitation?
Okay. The
As I'm
yeah,
doing it, I
see
think
the
in the of the building and construction workers.
yeah, yeah. See the new definition of contractor. Number one, as I said, he's now for the first time included in the definition of employer under all of the codes. And the new definition is a contractor includes one who supplies contract labor for any work of the establishment as mere human resource. Okay. Now, in labor law, up until now, you could challenge contract labor for abolition. As I said, for abolition, that's not baby goes out with the bathwater because the worker goes out with the contractor. But we've all been challenging it as sham and bogus. So you raise a demand saying that the contractor is actually a camouflage. He's just a smoke screen, and everything is done by the principal employer, and therefore you declare the workers to always have been the employees of the principal employer. And many workers have succeeded on that, including the Safai Kamgar of BMC just a couple of years ago. Now, even although under the earlier act, there was a similar definition, now they've added workers being supplied as a mere human resource. I mean, first of all, that language is truly offensive. And it seems to me that they are again and again trying to underline now that that you can't challenge the contract labor system and to even sham and bogus. And a contractor, it's valid for a contractor to merely supply workers as a mere human resource. Brick kiln workers would be, I mean, as she says, brick kiln workers are amongst the worst of the worst, and no changes have been brought to the Construction Workers Act, which was toothless to start with. So this is something we all have to, when we're talking about in this new era, and given for the unorganized sector workers, the migrant workers, the construction workers, these are the areas where we have to push for some reforms and some truly meaningful rights, and not just the welfare schemes which are being given.
Jane, please bear with us for the next few minutes. We have two questions, which are the two last questions for the day. The first question is from Neil about the context in which he phrased this question is that the BMC, that's the MCGM, would be waiting for the workers to strike. So how do we make it possible for workers to get back their right to strike without getting into any of the legal traps? And the second question, which is equally loaded, is there are two more questions, sorry. The second one is, do the new labor codes constitute new courts with a different composition, or does it continue with the labor code and the industrial courts under the Industrial Disputes Act? And the third question is, ITAC has called for a national migrant workers action plan. How do you see something like this panning out?
Okay, so the first one, very interesting and very pointed question on how will workers strike. When it's first of all, either you, and the problem is for workers like the Safai Kamgar, the contract workers cannot, for them to risk illegal strikes is very difficult in terms of saving their employment. We'll have to start playing with the definitions. For example, there's also, the new code has also defined strike as mass casual leave, okay, of more than 50%. Okay, so they've seen that this has gone on a lot, and they said that casual leave of mass 50% will amount to a strike. We'll have to start doing 49%. I mean, we'll have to start doing tricks like that and involving some methods. That's a very good question on the new courts. It's entirely different. Under the Industrial Relations Code, there will now be division benches. You have a single judge and you'll have a division bench who will comprise of a judicial member and an administrative member. There's a big, and they are to deal with 4 or 5 areas: the division benches, interpretation of standing orders, dismissal, closure, lockout, and strike. I think these are the areas. These will be by a division bench. Okay. The other members, then it says that all of the other cases can be distributed either to a judicial member or at an administrative member. That I find quite alarming, because if you have a single judge who is an administrator and is not a judge, and I'm sure everybody's quite exhausted by my talk you'll understand the complexity of labor law and how difficult it is, how different it is an exception to civil law. So having somebody who's not trained in that sitting singly and deciding matters is going to be very tricky, and more so because they've given the criteria for who can be a administrator, and it's somebody from a professional chartered accountant, somebody from industry, labor relations. Doesn't specifically say trade union. So that I feel can be a very could be a very dangerous area. Kanji, could you repeat the last was on the
last question was that one of the national unions has now come up with a migrant workers action plan, or has called for a migrant workers action plan, and your opinion was sought as to how do you see something like this panning out?
Superb. I mean, this is what we have to start doing. We have to have, this is precisely what we have to do. And we have to start having, even with migrant workers as dispersed as they are in the middle of this lockdown and pandemic, we have to start having all sorts of small actions, small programs to keep the unity together and to keep the issue burning. I think it's obviously a very good initiative, but we have to come up with more.
Jane, thank you so much for your time, and sorry that you had to stress out because of the internet access issues.
I'm so sorry with the technology. I'm using Sanjay's phone. For some reason, we lost Zoom contact in all our instruments in the house.
Thank you so much again. And for all the participants, in addition to the Shaalaa session that we are having tomorrow, the whole of next week, Shaalaa is hosting a 5-day capacity building for lawyers and activists interested on focusing on environmental laws with a people's focus. And the week after, a similar exercise is being undertaken to look at legal options and legal regimes and urban planning, and what does it mean for housing and livelihood for most of the poor in urban spaces. Please feel free to follow Shaalaa on its Instagram account or on its Facebook page or the YouTube page for more details. This is the flyer for tomorrow's session. Thank you again, everybody, for being patient with us, and thank you again for Jane, and particularly the team in the background that usually decides to keep me in the front for putting everything together. And thank you so much for bearing with us. Jane, thanks once more. Yeah.
In unmute.
Maybe are you going to switch on the camera?
Bye. Thank you.
Thank you.
ಟೆನ್ಷನ್ ಆಗ್ಬೇಡ. ನಾನು ಚಿಕ್ಕ ಲೆವೆಲ್ ಇಂದ ದೊಡ್ಡ ಲೆವೆಲ್ ವರ್ಗು ಅಡ್ವೊಕೇಟ್ ಗಳನ್ನ ಪರಿಚಯ ಮಾಡ್ಕೊಂಡಿದ್ದೀನಿ. ಸಿವಿಲ್ ಕೋರ್ಟ್ ಎದುರುಗಡೆ ಅಲ್ಲಿ ಹರಿಯೋರ್ಗು ನಂಗೆ ಗೊತ್ತು, ನೋಟ್ರಿ ಸೈನ್ ಹಾಕೊಡೋರ್ವರೆಗೂ ನಂಗೆ ಗೊತ್ತಿದ್ದಾರೆ ಬೆಂಗಳೂರಲ್ಲಿ.
Look happy, look happy. Bye, Archana. Bye, Anita.
Thank you everyone.
Okay, bye.
Bye, Archana.
Bye bye.